And my Lord, before before I leave the 20.1, the first respondent clearly in the affidavit in support of the answer to the petition denied this allegation. My Lord, there were affidavits of Nabakoza Rita, who was referred to here. And my Lord, Nabakoza Rita was very clear in her testimony. She also came to court to give evidence. She clearly even owned up the photos. And she even demonstrated to court that these are not the only photos. These were picked simply from a WhatsApp group. I have more photos. And she got to show court what she was doing at the time. She's a women counselor, and explained the circumstances of her actions. My Lord, there is even the affidavit of the person who printed, which was on record, and the Senabulia Dennis, which is on court record, with clear time stamps indicating the chain of this evidence. Counsel rose at some point and said, this person doesn't even know who printed. But the witness was here. He said, we went to one day. I don't know the name of the person. We always don't know the names of the people we find in these public use places. But what is good is that the person who printed brought themselves before court through an affidavit. And the petitioner had the opportunity, if he had any misgivings, to call this witness for cross-examination. Alice didn't do that. He shied away. And the person who swore, having printed for NAB Kenya, developed a running stomach and he was reported sick when he was supposed to be coming for cross-examination after NAB Kenya. And up to now, we've not seen that person. So that witness went away. So Senabia was available for cross-examination, was on the list of cross-examination after failing to break down Nabakoza. The petitioner feared to discover more truth. He said, Senabulia, no, that one I don't want. And my Lord, the effect of that is that that chain of evidence is very satisfactory to explain. But I would like to conclude by saying that, my Lord, the burden does not shift. The burden to prove rests on the petitioner throughout. I had counsel, my colleague saying, you know, you've not denied well. Your facts of denial are very few. No! The Lord does not place on me the obligation to prove denial. That is not what the law says. It is still your cross to carry to Golgotha. My Lord, on incident 2, under 20.2, my Lord, that is the one for chamber. My Lord, also would like to associate that this witness, first of all, makes allusion to Ben Ntale Mukasa and Sylvia Nachobe. My Lord, the first respondent saw an affidavit. He denied the allegations. Sylvia Nachobe and Ben Ntale Mukasa saw affidavits in which they also clearly denied these allegations. My Lord, the petitioner chose not to cross-examine these two people. Chamber Nathan was a self-confessed supporter of the petitioner, was a partisan witness by even his own admissions here. My Lord, although he talks about being bribed, it is also evidence of a self-confessed criminal. And my Lord, I'm going to demonstrate with case law authority. You cannot engage in criminality and then you come to court and you want to take benefit of the criminality. And court has been very emphatic on this. Section 87(2) makes the receiver of a bribe a criminal. It's an offense. And there are even penal sanctions that come with it. And court has guided, you can't be part of a cohort of criminality, then you want to play the victim before court. My Lord, this witness, just like all the other three, were asked here in cross-examination whether they ever reported any of these instances of bribery to the police constables, to the presiding officers, or to the candidates. And my Lord, they said, no, they never. And my Lord, I heard my colleague saying, no, the Lord does not require you to report. And my Lord, that's wrong and misleading. And as I'm concluding, I'll demonstrate to this court with case law authority that it is important. There are provisions in the Electoral Commissions Act, there are provisions in the Parliamentary Elections Act that require you to report. Those provisions in the law are not redundant. They are not put there without purpose. And the essence of reporting when these things occur is to make sure that we have a clean election. So if you fail to report, there are two preponderances. One, that your election petition is an afterthought. These things never occurred. But you are simply a bitter loser. And how do you account for your loss? At least run to court, such that your voters don't ask you, what did you do with the few votes we gave you? Secondly, it could also be true that one is simply part of the chain of criminality, or is the criminal themselves. So my Lord, the affidavit of Chamber Nathan Mwangozi, as I highlighted earlier, does not also indicate that this chamber and Sylvia Nachobe were agents of the first respondent. And my Lord, the law does not say you stop at agents. First of all, proving agency relationship is a cardinal requirement. But when you prove that, you do not rest and ask for water. The journey has just begun. Because when you prove that, then you must adduce evidence to prove that beyond being an agent, this person acted with the knowledge and consent or approval of the first respondent. And my Lord, I will make a generic submission on this. All the four instances, the witnesses that were brought to court, answered this question in the negative. And we were very deliberate, asking each of them in cross-examination, was this allegation bribery done with the knowledge, consent? And they said no. Others said we don't know. So if for you who has come to court you don't know, are you shifting that obligation and legal burden to court or the respondent? And I'll repeat, my Lord, that the burden does not shift. You come to court, carry your cross. So my Lord, incident 2 is not proved. And this is a lone witness. There are general allegations and submissions that were made by counsel that these are members of NUP. So by them being a member of NUP, then this one is their agent by implication. And my Lord, I'm going to address that because it is wrong, both in law and fact, in light of the political atmosphere in which we operate as a Mushokot. My Lord, the third instance under 20.3 is Maumbe George William. My Lord, I adopt my submissions on 1 and 2 on this third incident. And my Lord, I will invite court to note that this witness is a partisan witness, as he confessed in cross-examination the choice of his candidate. My Lord, this witness did not also report this to any authority, if indeed it happened. My Lord, this witness was asked, he said, you know, he gave me 5,000, he had a band of 5,000 he had received from the first respondent, Nalkola. My Lord, that was not in his affidavit. Because in his affidavit, he even does not make reference to the first respondent having knowledge. But as part of his campaign platform, as Avalia said, they think when they are here, it's a campaign platform to continue the campaign. He said, yes, that bundle he had gotten it from Nalkola. And we were very inquisitive. Please tell court, where did Nalkola hand over the bundle? He tried to do this and this. My Lord, I will invite you to go to the record when you retire. And finally, after being pressed for the third time, he said, no, I don't know where. Nalkola gave him that money. He said, fine, you don't know, that's good. Then how much was it? He said, I don't know how much it is. So my Lord, this I don't know witness, who doesn't know how much money was given, where, when, how much, cannot be relied upon by court to prove an allegation. And my Lord, I want to associate with the petitioner's counsel that you do not need very many witnesses to prove. Even one witness is enough. But the court has cautioned that that one witness must be truthful, cogent, and must prove the allegation to the satisfaction of court on a balance of probabilities. It is true, we can even believe one witness. But that one witness must be free from all biases of being a partisan witness. He must be free from all biases of being an accomplice in the crime. He must be free from all encumbrances as indicated. And my Lord, we submit that Maumbe doesn't qualify for such a witness. And this honorable court should not believe him at all in proof of the allegation of bribery. My Lord, I'll go to the last one. Who is Wanjala Solomon? My Lord, I will still admit my earlier submissions that Wanjala is a partisan witness. My Lord, Wanjala is a self-confessed accomplice in the crime. under section 87(2). My Lord Wanjala equally, when asked and tasked in cross-examination to prove if Nalgola knew about this, consented about this, my Lord, he broke down and said no. He broke down and said no. So, my Lord, his allegation was sufficiently answered to by the respondents, and my Lord, as I will demonstrate, even under 20.2, where we had somebody alleged to have received Wamukubira, these other persons who received the alleged bribe did not. Chibuka, my Lord, Chibuka Mary, Diana in 20.1 did not swear an affidavit to prove, to collaborate the allegation. And my Lord, even Wamukubira, under the affidavit of George Maumbe, did not swear an affidavit. And the same applies to Angela. So this makes them loners who cannot be easily believed. My Lord, as I take leave of this matter, I would like to draw court's attention to the authority of Acheng Saropendi. I think we have it. My Lord, that is volume 2, 676 in particular. Volume 2, page 676. My Lord, there in paragraph 20, court had this to say: that in election matters, partisan witnesses have a tendency to exaggerate claims about what might have happened during elections. My Lord, partisan witnesses placed in the context of what we are dealing with is Nabukenya Margaret, Chamber Nathan, Maumbe, George William, and Wanjala. That these ones have a tendency of exaggerating. In such situations, it is necessary, this is the Court of Appeal, to look for other evidence to confirm whether a particular witness is telling the truth. So, my Lord, as I take leave, I would like to say our colleague for the petitioner made some remarks about how this evidence is treated of illegal practices, and says there is no legal requirement to collaborate. My Lord, the authorities, right from the Supreme Court, the Kizabesi authority, which we retire and look at, where it comes to bribery, although it is proved on a balance of probabilities, but given its criminal nature, because bribery, unlike some other offenses, attracts with it penal sanctions. If it is proved here, court can even order police to begin from there. So court is required to consider more cogent evidence to its satisfaction, and in doing so, it goes slightly above the normal balance of probabilities in civil matters, in ordinary civil matters. However, it doesn't reach beyond reasonable doubt. And my Lord, the understanding is very clear, because only one incident of bribery, only one is enough to annul an election.
So you are not changing the standard of proof?
My Lord, I'm not changing. I'm affirming what the Supreme Court has said, and I'm affirming what is here.
I thought you had concurred with the for the petition that the standard of proof is
On a balance of probabilities.
now you are saying it is a little bit high.
My Lord, it's not me saying, I'm confirming even the authority before you. That is Sarah opinion, because that's what.
So they say it's a little bit high.
Yes. In electoral offences, and my Lord, we are flowing from Justice Odoch, the Chief Justice, that election petitions are sui generis. They are sui generis. Yes, they are civil matters, but one of a kind. Because we shouldn't lose track of that. And in all the authorities, even those that have been given, it's a requirement. Because one incident alone, even 500 shillings can annul an election. Even 500 in numbers, one, it is immaterial of the amount. Even one person bribed is successfully proven. So because of that legal burden, the standard is not as usual. The balance of probabilities is not a balance of probabilities ordinarily. In this sense, my Lord, when I fly. And my Lord, that is on 6-7. And my Lord, if I will even just go there, apart from the evidence of Agnes Ocho, the Court of Appeal was saying there is no other piece of evidence to corroborate Agnes Ocho's evidence. These allegations by Agnes required some other evidence from an independent source to confirm the truthfulness or falsity of her allegation. Just like all these who have come here, Agnes said I was given 2,000 to vote, to leave one person and vote the other. And she said, no, I was supporting this one whom they told me to leave. She was cross-examined and so many things came out. The Court of Appeal said, no, you can't rely on that one person. You need some other evidence. So my Lord, the requirement for collaboration is very imminent. And I will invite my Lord Court to go through that authority at those pages, and we shall be able to discern that there is need for collaboration. My Lord, there was something else that was highlighted by my colleague, which I think we need to clear. The requirement to report. The requirement to report to the Electoral Commission, to report my Lord, under Section 65 of the Parliamentary Elections Act, it makes it a requirement for a candidate or any voter present at a polling station to raise report of any incident that happened. My Lord, a candidate and a voter. Now, we had candidates, agents, all of these witnesses who came, they said they're agents. Others said, for me, I'm a voter. I'm not an agent, fine. But then 65 tells you that for anything that happens at the polling station, the offenses, the what, report to the presiding officer or to the constable, police constable. And my Lord, this was also traversed in the chain case before you on page 682. This was the petitioner's authority submitted. My Lord, I will not submit a different one, such that I can use the real one for the petitioner to drive this point home. My Lord, on paragraph 35, on the judgment of Justice Remy Kasule, as the then was, my Lord, in this instance of the son of the pending, these candidates talked about who were bribed in the morning, this happened, none of them reported. And the Court of Appeal says, under 35, about this Agnes Ocho, for example, she gave no plausible explanation for her deplorable conduct. If at all this was the truth, she did not also report this alleged bribe to any officials, including the elections officials or the police, who were readily available, which too was very strange. My Lord, the essence of reporting, at least it is the first instance. When they do nothing, the Act provides for the remedy. How do you do? If you report and nothing is done, what do you do? It's in the Private Elections Act. And the reason why it is important to report is that when you come for an election petition like this, we shall not look at you as a bad loser. You are in an afterthought, you are bitter. And my Lord, that is the Court of Appeal. And I will supply, my Lord, this Honorable Court with my Lord, in the case of Nakato Mary Annette versus Babili Veronica Kadogo, the Court of Appeal, 2016, Nakato Mary Annette versus Babili Veronica Kadogo and another, EPA number 89 of 2016. To the effect that at every polling station, my Lord, that's page 22 of that judgment, which I'm going to supply to court immediately. At every polling station, there is a police officer, constable, charged with the duty of keeping law and order. The appellant and her agents neither reported to the police about such illegal acts, and they did not also report to the Electoral Commission. The allegations coming up later can only be considered as an afterthought, not supported by evidence. We find on our reviewing all the evidence that the land trial judge was correct when he held that the allegations were not proved to the satisfaction of court. The judge's requiring corroboration of such evidence was done as an endeavor on his part to determine whether he could place any credibility on this evidence. He rightly evaluated all the evidence and gave the reasons for rejecting the same. And my Lord, the Court of Appeal found no fault on the trial judge in the way he went about evaluating such kind of evidence. My Lord, we invite you to treat this evidence the way it was treated in this case, and the Court of Appeal will not find you at fault even if they are. Reject the same, because it does not meet the legal threshold for reliance. And my Lord, as I also get this authority to court, my colleague talked about a new concept. And my Lord, that new concept is imputed agency. Imputed agency or political agency. My Lord, the law is clear on the agents envisaged in an election. My Lord, there are two agents. The polling agent that's under 51. Under section 51. Now, my Lord, the agents there are the polling agent and the representative. Because when you are nominating, there is somebody called the official agent who represents the candidate, because the candidate is expected to be running up and down. There are times when the EC has something to follow up. They must have a contact of somebody. Then, my Lord, you have the polling agents who represent the candidates at the polling station. Now, my Lord, section 87 introduces the concept that the candidate must have personally done so, or his agent. And these agents will include the polling agent, the official agent, and case law has extended this to agents who, by conduct of the party, of the candidate themselves, are represented to the people that this is my agent. And my Lord, that scenario arose in the Odo Tayewa case, which was cited. In that case, there was somebody who would move with the candidate everywhere. During campaigns, when the candidate would be called as a guest of honor, this person went. Said, I'm honorable. When they call, and these things happen even on barriers. This is like when we go to the village. Hopefully, I'm not giving evidence from the back. But they call a member of parliament, say, Honorable, Babidi, come and say something, then we see a Waswa coming. Then he starts speaking on behalf of the MP, like he's the MP, even gives Mabugo and other things. Now, the law has now said that, no, when one goes into that, and the principal leaves it continue for some time, and the whole public gets to know that where you select Uganda, you have seen Honorable X. Then in those circumstances, you may not easily deny agent's relationship. Even if that agent has not been strictly the one in the law, envisaged under the Electoral Commission Act and the PIA, then this one may also be your agent. So, my Lord, the petitioner had the obligation to demonstrate that for these alleged persons, which they did not do. And for purposes of saying that one is a member of the political party, so that automatically makes them an agent, is misleading. Council gave submission, making allegations on the affidavit of Lubongoya Lewis. My Lord, the affidavit of Lubongoya Lewis is on the first respondent's trial bundle. And my Lord, we shall invite this honorable court to peruse the same when you retire. There is nowhere in the affidavit of Lubongoya where he says that they had these officials campaigning everywhere. He gives his role as SG and his role in this campaign. Now, council says these Ntale, Ben, and Nabakoza are officials of the party. My Lord, is also misleading. And court handled the same in the case of Ntwantua Bagala versus Nabakoza. My Lord, I will present that authority to you. Because there the High Court had said, no, because these are all members of NUP, then they are all liable. The Court of Appeal said, no, belong to the same political party does not make one an agent. My Lord, this authority of Bagala Ntwantua versus Nabakoza Judith Narule. EPA number 68 of 2021. My Lord, the Court of Appeal here said, no, the petitioner must create a nexus and establish an agent relationship. It's not enough to say that these are party members. And even when you do so, you must go ahead and demonstrate that they acted with the consent. My Lord, that's on pages 31, 32 of the authority of Barbara Joyce, which are supplied to court. So, my Lord, it's also not true on the agency, on the political agents. My Lord, counsel cited a case. Counsel cited a case. Where's my volume 3? The Indian case of Gopal. I will just be sure, I wanted to note the page. I wanted to highlight the page of the Gopal case. My Lord, it is 1179, but in particular on 1181. On 1181, my Lord, first of all, we would like to say that that case is not applicable and distinguishable, because what counsel was citing is a provision under the People's Representation Act of 1951, Laws of India. And my Lord, I will refer court to go to 1181, from 1181. That is the context. Now, those requirements of extending agents to political parties and others is in the law. Now, the law governing the particular election we are dealing with is the Parliamentary Elections Act. And under Section 80 and then 87, it is directory and mandatory that you must establish knowledge, consent, approval of the candidate. It's not implied. So the authority cited of Gopal, India, was following that act, and that act is not applicable here because we have a specific law guiding this election. And to invite court to ignore the law here and import another law would be to inviting it to act by peculiar, which, as we have demonstrated to court, the same is not permissible. But my Lord, if I would, for purposes of counsel read out the most relevant part to his submission. And even if that case was applicable, which we say is not, because it's based on another law, even that law, if my Lord, when you retire, you go to 1182, to page 1182, it clearly shows that because it is common knowledge that in elections many strangers start taking interest who have directly no concern with the candidates or the election agents and have never been asked to do anything in the election. My Lord, in one of the Ugandan authorities, they call them overzealous voters. One who makes themselves an agent of you and they start doing things without your knowledge or what. It is incumbent that you must prove consent of the candidate, even under this act, which is not applicable, but we read it beyond where the petitioner and the lawyer had ended, and we invite court to also look at the same. So, my Lord, we, in brief, say that it's not true that we can have political agency. The party must prove. that indeed such a relationship exists. With that, my Lord, it's our submission that the issue on bribery be answered in the negative. And my Lord, for the record, just for reminder, I've spent 80% of my time submitting on a non-existent petition on bribery. Because as I highly highlighted, these grounds cannot stand on the ground of hearsay. But if court is not pleased with those submissions and the laws, and it goes to assess the same, we also say they do not meet the threshold. Most of like my Lord.
Okay, is there anything else? Anything else?
No. Just to supplement the case of the political agents. Yes. In the Supreme Court, in election petition number 1 of 2016, Amawa Mbabas versus His Excellency Yona Kaguta Museveni, on page 215 to 216, where the actions of the RDCs of intimidation were being attributed to the first respondent, His Excellency. This is what the Supreme Court said. The petitioner's attempt to attribute the acts of these individuals to the first respondent is not sustainable because there is no way a candidate would control some overzealous supporters steering posters of other candidates or supporters provoking fights and engaging in a fight with supporters of another candidate. In this regard, we found no evidence to associate the first respondent personally with his consent or with the alleged intimidation and disruptions of rallies. So, court removed the concept of political agency and hence vicarious liability of the same crime offenses. This was already submitted by the second respondent and the extract is highlighted. My Lord, we go to the second electoral illegal practice or offense of obstruction of voters. This is provided for under Section 90 of the Parliamentary Act, and the petitioner alleges 2 incidents, one happening at Kalanda's compound, end-to-end polling station, and she said she was informed by the said Badile Sherina Nasanga Deborah that this happened on the polling day. The other incident is the Kalanda's home, polling station O to Z, and her co-agent Kagumba and her were obstructed. My Lord, these were political agents, but polling agents that are giving evidence, and they are also partisan witnesses. I associate the same submissions that their evidence need to be corroborated. But my Lord, there are material contradictions and inconsistencies in their evidence. In her affidavit, at page 15 of her petition, she cites number of persons that carried out the said obstructions. The Kenya Bone, paragraph 15 of her affidavit. I believe it's paragraph of the petition, paragraph 16. I'm going to confirm the paragraph. It's paragraph 9.2 of her petition. It is paragraph 18 at page 15 of her petition. Sorry, my lord. However, neither Vavili in their affidavits mentioned Fred, Chibirango Fred, as being a participant. They mentioned a one participant who is female, Omusango, but none of her witnesses. This is in her affidavit, in paragraph 18. When you go to the affidavits of the witnesses, they mentioned no female participant. Yet in her affidavit, she has a female participant by the name of Omusango. Omusango is not mentioned anywhere. Nansanga Deborah, who was meant to corroborate the evidence of Babide Sherina, mentions a different Sherina. She mentions that the person whom she saw at that polling station was...
Sorry, Council, this Omusango.
Yes.
Fred. Repeat your point. I didn't get it.
The point is there are these evidence presented by court has material inconsistencies.
No, here they are mentioned in paragraph 15. Then,
paragraph 18.
18.
Yes.
Then at some point you said
both witnesses. They are affidavits. Both witnesses, Babide Sherina and Nansanga Deborah, don't mention of the female participant. For her, she says there was Omusango in paragraph 18 of her affidavit. Yet the witnesses all mention only male persons that are alleged to have committed the crime. Let Nansanga Nansanga, in her own affidavit evidence, that is paragraph 3 to 6 at page 1260, she says she arrived at Kalanda compound polling station end to end and alleged saw her friend Nabukena Sherina being beaten. She does not identify, they say, polling agent of the petition, who is the Babide Sherina. So these are two different people. Yet she was meant to give evidence in corroboration of Babide Sherina. They say Nabukena Sherina never gave any evidence of her being beaten. Nabukena Sherina, Babide Sherina says that she was beaten, but no medical report. She said 3 men came being led by Chibirango, beat her. She doesn't present any medical report of the said allegation, which body part she was indeed to confirm whether she was indeed beaten. And she didn't report anywhere. My Lord, what is strange with the Babide Sherina, she said after all that, voting continued. If she was indeed obstructed, voting continues, She was rescued. Then, at the end of the counting of votes, that's when she requested the presiding officer to make that in his report. If she was indeed obstructed, she wouldn't have even carried out her work, because obstruction literally means being stopped or being prevented from what you are doing. She continued carrying her work as a polling agent until the end. She said she reported a case of threatening violence. No investigative report has been furnished to know where its stage it has reached. Nothing. My Lord, with these inconsistencies, contradictions, and speculative assertions, this evidence is indeed unreliable and unpersuasive. I want to associate my submission to my colleague. The averments made by the petitioner that this act was done with the knowledge, consent, and approval by the first respondent, as averred by the petitioner herself in paragraph 18. The same content is not there. Therefore, they say two affidavits, and she mentioned her informants about the same as being Babirie Sherina, Chemakai, Eli, and Nasanda, Deborah. The said affidavits are contradictory and do not corroborate. Therefore, this evidence is also here, my Lord. And should be disregarded. My Lord, the presidential petitions of Amawa and Babas and the act itself says these offenses are personal, any person. When you read section 90, it begins with any person. A person who at an election, even the one for obstruction of polling agents, it says a person who obstructs polling agents. Going back to referring to the Supreme Court decisions in the last paragraph, with regards to the electoral offenses, the Supreme Court said the offenses, lastly, the acts alleged of intimidation and interference with electionary activities of other persons were committed by individuals. And section 26 of the P provides for a penalty, which are 90 and the 102, against the person who committed the specific offenses specified in the provision. That is page 215. Therefore, these personal offenses, it was wrong to attribute them to the first responders. What the petitioner would have done is commence criminal proceeding against the said persons themselves. The Chidirangos, the Honorable Barimwezos, the Sam Kasirie, and the Uma Skopia, as alleged. My Lord, the other offense is obstruction of electoral officials as averred by the petitioner in paragraph 3.1, 9.31 at page 6 of our petition, and paragraph 19, 1 and 2. 19.1 of our petition, which is page 15 of our affidavit. She alleges that electoral officials were obstructed. They say electoral officials are not named. They say electoral officials are not named. That is the affidavit of Chimakai Chikamai Eli. Chikamai affidavit is on 1239 of the petition. What is strange with Chikamai's affidavit, she says, although she says under paragraph 7 that the presiding officer reported these activities to police. But it is impossible for the presiding officer to leave any polling station during the conducting of polling to report a case. He has to be present until counting. And she does not state in her affidavit whether polling was stopped during the time the presiding officer was reporting the alleged offense. The second respondents denied this incident in their affidavits. They say there was no disruption of their polling officers or their employees, that they conducted the election as required. The victims themselves that they are saying were obstructed are not complaining. So we would wonder where the petitioner got the local standard to make such an allegation. If the victims themselves are saying we conducted the election without any disruption. When you read the further evaluation of her affidavits, she says that it was Hildaman, Hilary Chiaga at Kazo, Angola. The time, she does not specify the time, but from the reading, it happened between 10 a.m. to 11 p.m. That is under paragraph 5, 4 and 5. She puts Hildaman at Kazo, Angola polling station, Nak to Namaz. Yet, her co-witness or witness of this puts Senator Lawrence under paragraph 12.2, 19.2, puts the same Hildaman. Masuti's affidavit is on page 1262. At the same time, well, Hildaman is another polling station, that is Namaz. He puts Senator Lawrence Masuti, puts Hildaman with Dennis Rumomboya under paragraph 7 on a different polling station, which is Kazo, Angola, SP to Z. You really wonder how could Hildaman be in the same place at the same time, two different polling stations at the same time. These glaring contradictions indeed cast doubts that the said offense was indeed committed by the alleged persons. There was no proof that Hilderman was an agent, and these acts were done with the knowledge, consent, and approval of the first respondent. Therefore, my Lord, we pray that you find that the petitioner adduced insufficient evidence to prove the same, and the said direct offense have not been proved. My Lord, we go to the last electoral offense. The petitioner alleges there were 4 incidents of campaigning on polling day, contrary to section 63(1), 2, paragraph A and B, section 100, subsection 1, paragraph A, D, subsection 2 and 3 of the Parliamentary Elections Act, Cap 177. My Lord, the reading of this act does not bar campaigning on election day. It only stops, gives a radius. You can do it, but on a radius between 100 or 200 meters from the polling station. Campaign. These provisions prohibit campaigning beyond midnight on the eve of polling day. Then to campaign